This is Chief Justice William Rehnquist, and he wrote the opinion for a case called U.S. v. Lopez that was decided in 1995 by the U.S. Supreme Court. This case was a 5-4 decision, and it had to do with the 1990 Gun-Free School Zone Act that Congress had passed. Congress had utilized the powers under the Commerce Clause in Article 1 to put restrictions on gun access at schools. Here's what happened. Mr. Lopez was in 12th grade. He was a senior in a high school at San Antonio, Texas. He had brought an unloaded weapon to school to sell to a friend. He was charged with a violation of the No Guns in Schools Act. He appealed all the way up to the U.S. Supreme Court. It went, and the U.S. Supreme Court set out a standard when it came to using the Commerce Clause, something much more restrictive than what Congress had used previously. Justice Rehnquist said, the possession of a gun in a local school zone is not an economic activity that might, through repetition elsewhere, have a substantial effect on interstate commerce. Because of that, Justice Rehnquist had said Congress had overstepped its power by setting out this act that restricted guns in schools. The act was deemed unconstitutional and the case was thrown out. So there you have it, U.S. v. Lopez, one of the biggest cases to come down to set out limitations on the commerce power for Congress.